I'm very honored to be here and be presenting to members of ANPA. Let me share my slides first. Oh, excuse me. Can I share that? Oh yeah, as I'm waiting for the slide to open, just a little bit about myself. I'm an immigration attorney. I've been practicing immigration law for 12 years now. I've been focusing on especially employment-based immigration law. So I deal with work visas, employment-based petitions, and all kinds of student status issues, because a lot of those cases, the beneficiaries are in student status. So if you have any questions related to these work visas, employment-based immigration, or just student status overall, feel free to let me know. Excuse me, sorry. I have a little difficulty sharing my slides. If any of you have that, would you mind open the slides for me? Sorry about that.
Do we need to make her the host?
No, it's fine. I think.
Yeah, I make her.
It's probably me.
Okay, I'm downloading it, so if I can. Okay. Did you see my screen?
Yes, thank you so much.
Yeah, welcome. Just let me know when I need to press another slide.
Okay. Thank you very much. Okay, yeah, we can go to the next slide.
Yeah, Tikaji, just make the presentation mode, please.
Oh, sorry.
Yeah, thank you very much. Yeah, so first is the disclaimer. Okay, so everything I share today is for informational and educational purpose only. So that won't be considered legal advice. Okay, even I answer your question during the Q&A session, that's going to still be general information because I might not know your full personal status history. So please make sure you take those information as educational purpose only. And also today's session, I know it's going to be recorded, and ANPA probably will share the full video with members after the session. But for yourself, feel free to take notes and watch the replay. But please do not share anything from today's session and to a third party or to social media, without consent. All right, thank you. And next slide. Yeah, so that is about myself. I'm also a specialist certified in immigration law by the State Bar of California. I myself is located in Los Angeles, California. But immigration law is federal law. So we also represent clients all over the nation, outside California, or sometimes outside the states as well. So again, if you have any questions, feel free to let me know in the chat box. We will get to that at the end of today's session. Thank you. Next slide. All right, so that's going to be the agenda for today's session. We will give some overview of how the system works. If you want to get a green card, what are the options, especially for researchers, right? So I know a lot of you who are attending the session today are researchers, either maybe currently in school in your PhD program, or maybe you have already graduated. So we're going to go over some of the common paths for especially researchers. And especially we're going to go a little bit into the details of EB1A and EB2NIW, because those are the two most common immigration petition filed by researchers if they decide to self-sponsor, self-petition, right? So you don't need someone else to petition for you. You don't need your employer to do that for you. You can start the process by yourself. So that's EB1A and NIW. We are also going to go over some of the projections about the policies during the new administration. As that is projection, right? So we don't know for sure what's going to happen, but we're going to go over some of the changes that we have seen, during the first Trump administration and the last 4 years during the Biden administration, and what we expect to see maybe in the next 4 years. But again, the projection part is quite subjective. We still need to wait until the actual policy or new regulation to be released to know for sure, what kind of changes will take place. All right, let's get started. Okay, so next one.
The next one.
All right, so we go to the next slide. Oh, yes, thank you very much. Okay, so this is an overview. This is a very important concept. Okay, there are a few very important key concepts. I hope you can take as the takeaway from today's session. If you know a lot of the details might not be remembered, that's okay, because we will go over a lot of things. You don't have to remember everything, but there are a few key concepts, and this is one of them. So green card and work visas, they are two very independent process. They are independent from each other, right? So let's say if someone wants to start applying for the green card, they don't have to be in any status to do that. So a lot of the times we are asked by clients, can I start the green card process now? I'm still a student. Yes, even you are a student, you can still apply for the green card or start the green card process. Or sometimes people feel very complacent after getting a work visa. Somehow people are under this impression, maybe the green card would arrive certain years from the time they get the work visa. No, that's not how the US system works. I know in some countries, like say, if you have work visa for a certain number of years, you're going to be granted the green card, but that's not the case in the US immigration system. So no matter how long you have a work visa, it won't automatically become the green card. You still have to proactively apply for it. So that's very important to understand. That means you would have to plan for both, right? You have to plan for the green card and you have to plan for the work visa. And then the next question is, a lot of times, our clients would ask us, okay, in that case, why don't we just apply for the green card, right? That is for the permanent residency. If I get something permanent, why would I bother to get something temporary like work visas, right? Yes, that's a great question. Well, the answer is because to get a green card, it takes a while. It takes time. Okay, the green card is a two-step process. First, you file something called immigration petition. Okay, I will explain later what that means. Okay, but just remember, you file something called immigration petition first, and then you will file, if you're in the US, you will file something called adjustment of status application. You will file to apply for, adjusting your status to permanent resident. Okay. So those are the two steps. So the form usually used in the first step for the immigration petition is called I-140. Okay, so for those EB-1A and AW, you will file something called I-140. What is that? What's the difference between the two? Okay, when you are filing the immigration petition, let's say the I-140, you're proving to the immigration agency that you have all the qualification, especially the professional qualification, um, to get a green card. So they all come with different criteria, right? Like say EB1A has its own criteria, NIW has its own criteria. So depending on what type of petition you file, like what category you are filing under, you will have to meet different criteria. So at this stage, you are mostly focusing on the professional achievements you have. Okay, but if you decide to go through another route, let's say if you are married, like your spouse is a U.S. citizen or your spouse is a green card holder, then what do you file would be some marriage-based immigration petition. Then you would have to prove, the marriage is a real marriage, that is a bona fide marriage, right? So this is where you prove that you have the kind of qualification to get the green card. So, if that's achievement based, then you have to prove your achievements. If that's marriage based, then you have to prove the marriage. Okay, so that's what it does. However, merely filing that immigration petition won't give you any status to stay in the US. Okay, so that is also very important to remember. I know a lot of people who just start to get to learn about the immigration process usually get very confused. Like, okay, if I file that petition, can I stay in the US? No, you cannot stay or work in the US merely because you filed this immigration petition. But you have to have an immigration petition in order to file the second step, which is the adjustment of status. That's why you cannot skip the first step. You cannot go straight to the second one. You have to have immigration petition. Okay, so at the time you file the adjustment of status application, that second step, that is when you can stay in the US. You're authorized to stay. So that form is called I-485. Okay, so that's when you can stay. Okay, then some of you might ask, like, can I file both together, right? Like, do I have to wait? If I have to wait, how long do I have to wait? Okay, it really depends. It depends on the category, like which category you're falling under. So again, like I'm gonna introduce the next concept. All right, next slide. Okay, thank you very much. Okay, petition and I-485. Okay, so sometimes they can be filed concurrently, the same time. For example, if someone is married to a US citizen spouse, they can file those concurrently. So for people who are born in Nepal, right? Usually, if you file under, like say, oh, this might not be correct. So here, like we're noting this is for like some other countries, but can we go to the next slide? And next, yes, thank you. Okay, so for people from Nepal, like if you fall under the EB1 category, okay, then that would be like there's a letter C, that means current. There's no wait time. That means you can file both together. Okay, but in some other categories like EB2, EB3, EB4, you would see a date. That means you cannot file them concurrently. You have to file the petition first, and then you have to wait until it is your turn to file the I-485 next. All right, and remember, this is important because you won't have any authorization to stay merely because you file the first immigration petition. Okay, you can only be authorized to stay because you filed the I-485. I'm talking about your authorization to stay from the green card filing. It doesn't affect your authorization to stay if you have other underlying status. For example, if you have the F1 status, if you have the H1B status, or if you have the O1 status, as long as that status is lawful, you can still stay in the US. So, but if at some point you don't have that underlying status anymore, then you can only be authorized to stay in the US if you have already filed the I-485 application. Okay, so that's how it works. And then let's look at this visa bulletin. I'm not sure how many of you have read the visa bulletin before. I assume maybe not all of you or not most of you. So I'm going to spend a little time to explain how the visa bulletin works, because this is also some very important concept when you start the green card application, especially for a lot of you might go through the national interest waiver route, right? So you probably will have to read the visa bulletin. The visa bulletin is something the US Department of State releases monthly. So each month it would look different. It might look different. So you will see there's some country name, right? And there are some categories like first, second, third, fourth, and fifth. Okay. You might be wondering, then where's Nepal, right? The country name is not there. All right. So except those countries listed, all other countries would look at that first column, all chargeability area except those listed. So for applicants who were born in Nepal, that's the column you will be looking at. All right. And what does that mean? There are some dates and there's this letter C. What does that mean? Okay, C means current. Current is a good thing. Current means there is no extra wait time in that category. That extra wait time is the time between filing the immigration petition and filing the I-485. Okay, it doesn't mean like there's no processing time. Like if you file today, you're gonna get approval tomorrow. It doesn't mean that. Whatever you file, it still takes time to process, but there won't be additional wait time between the filing of I-485 and the I-140, the immigration petition. So that's what the letter C means. Okay, how about those dates, right? Let's look at maybe the or chargeability second, how to read that. Okay, so second means EB2. Okay, let's say within EB2, there are two types of EB2, right? There's the employer-sponsored EB2. There's also the self-sponsored NIW. So if you file NIW, you're going to be looking at that box. Okay, second or chargeability. So currently, it says April 2023. Okay, remember this is the January 2025 visa bulletin. That means in January 2025, those who filed their immigration petition back before April 1st, 2023 would be able to receive the green card. Okay, so that just give an idea like how long the process could take. Roughly, you can assume that takes at least almost like two years, right? So if the visa bulletin moves steadily, someone who filed the immigration petition before April the 1st, 2023 would be able to receive the green card January 2025. And that's the earliest, all right? It doesn't mean like on that day everybody's gonna get it, but if your case gets processed timely, you're gonna be receiving it. So that gives you an idea how long it takes to get a green card. Okay, then the next slide.
But why it is not move?
Okay, thank you very much. So that there is another chart for date for filing. Okay, you will see a different date here. Everything else looks the same, but the dates are different. Okay, that is about when you can file for I-45. Remember, the first step, immigration petition. Second step, you file for the I-45. So that is, you actually apply for the green card. You don't have to prove your professional achievements anymore, but you have to prove you have a lawful status in the US. You have been maintaining that status. That's what you need to prove at the time you file I-45. Okay, so here we see a date, August the 1st, 2023. Okay, that means for those who filed the petition before August the 1st, 2023, they would be able to file the I-45 at least in January 2025. Okay, so that's how that works. That is much better, right? Like you only have to wait half a year to be able to file the I-45. So that's not too bad. But remember, they are not filed concurrently. You still need to wait. You have to check the visa bulletin and wait for the date, like your date, showing in the visa bulletin, so that you can file the I-45, and then you are getting closer to receiving the green card. Okay, so that's how it works. So that means like, how do you understand those two steps, right? Sometimes for a lot of the applicants who just start getting to learn the green card process, that still sounds very confusing. Like, oh, there are two steps, right? So remember the first step, when you file an immigration petition, that's almost like you go to the DMV, right? Like you go to the DMV lobby and you take a ticket. That is your ticket. All right. But just because you have a ticket, that doesn't mean you can submit your application, right? So you wait. And then you look at the visa bulletin. This is like they are announcing what number is called, right? You can go to the window. Okay. So if your number, like your date is before the date in the visa bulletin, that's almost like your number is called. Now you can go to the window to submit your application. Okay, so that's how it works. You still have to file that second step in order to really, apply to adjust your status to be a permanent resident. So those are the two steps involved in the green card application. All right, if you have any questions, feel free to leave that and we can get to it at the end. Okay, next. Next slide, thank you. Yes, okay, these are some of the common options to get a green card. We're going to be focusing on the ones that are most commonly used by researchers, such as the EB-1A, EB-1B, and NIW, National Interest Waiver. It doesn't mean you cannot go through other routes. Okay, so let's say if you're married to a citizen, to a permanent resident, you can still, go through the marriage-based petition. And also one person can have multiple petitions, okay? You can have a merit-based petition and an employment-based, or you can have an EB-1A and an NIW as well. So it really depends, like what you would qualify and whether you would need more than one. But, you can have both, and eventually, depending on which line moves faster, you can go file the I-45 under that category. Okay. Next slide. Okay, thank you. And next. All right, let's play the full text on this slide. Thank you very much. Okay, so we won't go into too much detail into the EB-1A, but I want to still give an overview of what are the criteria for, let's say, the EB-1A extraordinary ability, because for applicants born in Nepal, this would be still the fastest route, like for among all the EB categories, right? We notice this one has the letter C, current. That means there's no additional wait time to file the I-45. But it does have a higher standard than some other categories. So that's for people with extraordinary ability. It's not for scientists only, but a lot of scientists do qualify if they have a lot of great achievements. Okay, so you have to prove you have sustained national or international acclaim, and you seek to continue work in the area. That is also important. So if you decide to do something else in the future that's totally irrelevant to what you do right now, that may not work, okay? And you need to show that substantially benefit US in the future. That's usually not too hard for most researchers' work. The only thing is making sure you have sustained acclaim. So let's say if somebody, usually that happens to someone who haven't done the work for a long time, like maybe they changed field and now they want to claim extraordinary ability, that may be tough. But if you have been continuing working in the same field, you won't have to worry about that. Okay, next slide. Okay, and for the EB1A, this is a two-step analysis. First, we need to prove either you have a one-time achievement or you meet 3 out of the 10 criteria. One-time achievement is relatively rare. That is like a Nobel Prize, right? But you don't have to have a Nobel Prize to apply for the EB1A. Most people, I would say, would qualify based on the 3 out of the 10 listed criteria. So that is the first step. The second step is we need to show, overall, like with all the totality of the evidence, the person has proved the sustained national or international claim, and everything indicates the person is one of a small percentage at the top of the field. So that's kind of like a vague, but basically it means like you cannot just show like I have maybe one piece of evidence for each of the 3 criteria, and then I claim EB1A. You cannot do that, okay? They still have to look at the quantity of the evidence and the quality of the evidence overall when they are going through the final merit analysis in the second step, okay? So what are the 10 criteria? Let's go to the next slide. Thank you very much. Okay, we won't go through them too closely, like one by one, but I'm gonna be mentioning a few criteria that are usually claimed by researchers. Okay, one of those would be the award. If you have, like, say, an award on your thesis, your PhD thesis, from a well-known university, right? That can be the award to qualify under this criterion, okay? But it's not that common, but in case you have one, that can qualify. However, most fellowships do not necessarily qualify under the award criterion. The difference is usually fellowships are granted for you to do something in the future, but award is something to recognize your past achievements. So that's the difference. So usually we have to look at those awards, prizes, acknowledging your past achievements. Okay. And then membership, sometimes we claim that, but remember the membership for the EB1A would have to be the kind of membership in associations, which require outstanding achievements of their members. So if there are some professional associations where you can pay a fee and become the member, usually those memberships do not qualify for EB1A purpose. Okay, published material, I would say it's not that common for researcher cases, but if you do have some published material, we can look at whether that is published material in professional publication or in some major media. So I would say it's not too common, but sometimes we can still use that. The fourth one is very commonly used. It is participation, either individually or on a panel as a judge of the work of others in the same or similar field. Okay, that is commonly used for researchers' cases because a lot of you may have been the reviewers of journal papers or conference papers, so that would qualify under this criterion. Okay, the next one, original contributions of major significance. That sounds hard, and it is hard, okay, because it's kind of subjective. And a lot of times we would try to argue, our clients qualify under this one because they have high citation numbers. So citation number is not something among the 10 listed criteria, but usually we can use the citation number to argue someone has made original contribution of major significance in the field. It gets a little tricky here because a lot of times we're asked like how many citations I have to have, right? There's no magic number. We have to do it by case by case because each field is different, right? Usually we would look at the papers, all the other papers published from the same year in this field. Where does the current paper rank, right? So we can use citation number under this criterion. Okay, next one. All right, the sixth, authorship of scholarly articles. I would say most of you probably qualify, as long as you have published scholarly papers, you would be able to qualify under this criterion. And this one doesn't have to factor in the number of citations, as long as that's scholarly papers. The seventh are not that related to researchers because it's about display at artistic exhibitions. It has to be artistic. That's usually saved for artists. The eighth one, performance in a leading or critical role for organizations or establishments that have a distinguished reputation. That one is currently being used a lot for researchers as well. For example, if you are working in the industry and you are working as a, like maybe a senior scientist or scientist, and you play a very important role in the company, we might be able to claim that. But then who determines you are a critical role or not? Usually that has to be done through some support letter from your manager at the company. Or if you are a postdoc, right, at the universities, or you are an associate professor at the universities, that would be proved through like the school letter, or maybe, your supervisor's letter, okay? Next, high salary. Usually that applies to those who work in the industry. Again, there's no magic number, okay? We still have to compare your salary to your peers in the same field. The next one, commercial success. In performing arts, that's for artists only. That's not for researchers. Okay, so as we have quickly gone over all these criteria, you can tell the most used criteria would be authorship of scholarly articles, judge the work of others. Those two, I would say most of the researchers would be able to prove, after graduation or even when they are in PhD programs. But usually the challenge is to prove the third one. Okay, some of you might be able to prove the third one through the critical role at an organization with distinguished reputation. Some of you might be able to prove original contribution of major significance through your citations or maybe commercialized patents, but that would be case by case, and that's usually the challenge for EB1A. So that still is not an easy to attain, but it's still doable if you can meet at least 3 of the 10 criteria. Okay, next slide. So for some of you who might find yourself not that maybe qualified for EB1A yet, okay, yeah, we can probably skip this one and the next one as well. yeah, we have already pretty much covered those. Maybe the next one. Yeah, for some of you who maybe find it a little hard to meet the 3 out of the 10 criteria under EB1A, then don't worry, okay? You may still qualify under EB2 National Interest Waiver, okay? What's the criteria? First, we prove you have an advanced degree, okay? That means like a master or higher degree, right? Or if you don't, then you have to prove the exceptional ability, like 3 out of the following 6 criteria. However, please remember this is either or. If you have the advanced degree already, you don't have to worry about the 3 out of the 6 criteria anymore. I assume most of today's attendees have an advanced degree. Okay, so then we would just go straight to the next slide. Like, what are the actual criteria? Because this is the prerequisite. Okay. Right, so compared to the EB1A, this one has a lower standard. It has more room for creative arguments because we need to show 3 things. And those 3 things would look very different from the 10 criteria we have just gone through, like for EB1A, right? EB1A has really specific criteria, like, papers, right? Media reports, like membership. And let's look at the 3 things for NIW test. First, you need to prove the proposed endeavor, like you have a proposed endeavor to work in the US, right? And the proposed endeavor has substantial merit and a national importance. What does that mean? Well, that is really hard to specify to a very specific criterion as EB1A. But basically, whatever you propose to do have to benefit more than let's say your employer or your clients. It has to have broader impact. So that's what the national importance means. For most of the case, if you do research work, I would say the research work usually has national importance because it's not to just benefit one company only, right? So that's what it means. Proposed endeavor has substantial merit and national importance. Second, the petitioner, okay, is well positioned to advance the proposed endeavor. What does that mean, right? That usually means, okay, first you give USCIS a plan, what you plan to do. The second, you need to prove that you have the ability to carry out that plan. So we would look at your educational background, your work experience, your record of success to show that you would be able to do what you propose to do. That doesn't sound very hard, right? The first 2 criteria. And then the third one, on balance, it would be beneficial to the US to waive the requirements of a job offer and the labor certification. Okay, what does that mean? Okay, again, that's a very subjective balancing test. That means the officer can look at the person's achievements to decide whether the person has some unique achievements that cannot be put into a labor certification. Okay, that I may need to explain a little bit what that is, right? National interest waiver. Okay, why it is a waiver? What does it waive, right? It waives the labor certification because usually under the EB2 category, if you want to get a green card, you need an employer to sponsor you, and the employer has to prove through a labor certification process that there is no minimally qualified US workers. Okay, they have to post ads, right? To post ads and do interviews and to show there's no qualified US workers. So that is a labor certification. For the labor certification, an employer has to sponsor. You cannot self-sponsor. And then the employer has to do a labor market test. But if you do NIW, you don't need the employer to sponsor you and you don't have to do a labor market test. So that's what it waives. In order to do that, you have to show that you have something very unique, okay, to contribute to the US. You cannot just be a very good worker at a company. That doesn't work. So here, the trick is we have to show what kind of unique contribution this person can bring to the US, right? You have to have this kind of impact to the field, some of the contributions to the field. Usually that is proved through either papers, conference presentations, or maybe patents for researchers. Okay. All right, next slide. So that is about the EB1A and the NIW. Okay, some of you might be wondering, then that's it? Like for NIW, I don't have to have, these other things, awards, media reports, but then how many papers do I have to present? Again, there's no fixed number. We have seen people who have lots of papers and hundreds or even thousands of citations. Of course, that is very strong case for NIW. But on the other hand, we also have seen people who have like maybe 2 articles or maybe like 10 citations, but some recommendation letters, they may be able to have a good NIW case as well. So it really depends. Usually when we evaluate the NIW case, that's when we have to really do a very case by case evaluation depending on the kind of work the person does. Okay, so we have seen a lot of good favorable policies from the current Biden administration, especially for researchers. That includes some very relaxed rule for EB1A and also NIW. It doesn't really change the criteria, okay, because that's in the law, right? That's not changed, but they change the way some languages are interpreted. For example, let me give you an example. The awards in EB1A cases. In the past, like say during the first Trump administration, those awards have to be national or international awards. And those awards have to be open to everyone in the industry. If it has like an age limit, right? If it says like young scientists or young researchers award, that won't count. It has to be offered to the whole industry. However, during Biden administration, they relaxed that rule quite a bit. Even, it has some limitation, like say it's granted to young researchers. It still can qualify as the award that has national or international acclaim, as long as we can have some proof to show, the impact of the award. Or if you are a PhD, you have some thesis award from a school, and this is a high-ranking school, then we can still qualify. So you can see there's some subtle difference that can make a huge difference in individual cases. So that's what happened in the past 4 years. Okay. Next slide. And here we can also see this policy about student status can be the beneficiary of an approved or pending immigration petition. This actually is not something new, okay? Student can always apply for immigration petition, right? As we said at the very beginning of our today's presentation, whatever status you're in, you can start the green card process. However, USCIS released this rule last year just to clarify that student status won't have to worry about the impact of filing the immigration petition on their, let's say, OPT. Okay, because they get that question a lot. If I file, like, say, an immigration petition now, would I still be able to get, like, say, OPT? Yes, you still can, so don't worry about that. All right, next slide. This is like a trend. Some people have been very concerned because it seems like the denial rate, let's say NIW, even for STEM major, has gone up. That is true. Even though the Biden administration released some very favorable policy, especially back in 2022. But because the filing number went up so much, that they started to adjudicate more strictly, especially in 2023 and 2024. But if you are a researcher, a PhD who have published papers, have citations, I don't think you have to worry too much, because the denials a lot of times would happen to like people who may not be that qualified but still file their case anyway. So that probably is a big cause of the rise in the denial numbers. Okay. All right. Next. Okay, so this is just an illustration about how some different applicants can get a green card. So you basically just want to show you can go from any status to get a green card, right? You can go from F1 to a green card, and you can go from F1 to H1B and then go for a green card, right? So there's really no fixed pattern of you have to get into this status first and then get H1B and then you get a green card. You don't have to do that. But I need to give you some heads up that you don't have to be in any work status to file for the green card. But if you travel on F1 visa after you start the green card process, you might still want to check with your attorney if there are any risk of getting the renewed F1 visa overseas. So that's something you may still want to check if you decide to leave the US. But if you don't leave the US, you're staying in the US and you want to start all those process, that's not a problem. Okay, next slide. Okay, so we're almost at the end of our presentation, and then we're going to open for Q&A. I'm going to go over a little bit, what are the changes we expect to take place. Just a quick summary of what has already happened in the past, especially during the 4-year Biden administration. As we mentioned, a lot of relaxed rules, interpretations regarding O1, EB1A, and NIW. So that is good news for researchers. But would the new administration takes those back? Would they revoke, rescind those policies? Maybe. And they have the authority to do that. Whether they would do it, we will have to wait and see. That's definitely not a priority for them, right? That's not the first target, but maybe they would make it more strict as they take the office. All right. Something bad happened during the Biden administration for employment-based petitions would be the labor certification. So if you are, let's say, work for a big tech company, Amazon, right? Google, Meta, right? If you work for those big tech, you might have heard that those big tech has already suspended their perm program, the labor certification, because there has been some, investigation from the government side on those big tech. So they are no longer sponsoring foreign workers through the labor certification process. That also means, for especially researchers, starting the process on your own would have a lot of benefits, right? If you wait the company to start the process for you, then you are really at the mercy of the company. If sometimes the company policy changes, then you would be caught in a very difficult situation. So if you can start the process yourself, then just go for it. There's also a new H1B rule that it's actually released this week. So when I prepared that slide, we were expecting that rule to be finalized, but now it's finalized. There are a lot of changes there, but I would say maybe the most relevant changes for a lot of you is if you are starting your own company, if you are the majority shareholder in your own company and you want to petition yourself for H1B, it is possible now. Okay, it wasn't possible before if you are the majority shareholder in the company and you want to petition yourself for H-1B. However, remember, if this is a for-profit company, usually you still have to go through the lottery unless you say you work with a university, right? I know some university may have that kind of program like incubator, right? So they have some entrepreneur startup founders work on the university campus, and they have some collaboration. If that's the case, maybe you would be exempt from the lottery, exempt from the cap. But if you don't have that kind of relationship with the university, you would still have to go through the lottery. But it is possible that you start your own company and be petitioned by your own company under the H-1B. Okay, next. Yeah, that's pretty much it. The beneficiary owner can petition for themselves. All right, next slide. Okay, we don't know what's gonna happen, right? So personally, I do feel like this time it's a little different from the first Trump administration, because last time it was all Stephen Miller policy, right? Stephen Miller is the person who was behind all these anti-immigration policy during the first Trump administration. You might have heard that name from the media from time to time. Yes, that's the person who made all those policies. He's still going to be the deputy chief of staff, especially on policy this time. However, as we know, this time, there's Elon Musk, who's always, very pro legal immigration, who always want to, bring something maybe good for the work visas, right? Because anyway, like Tesla also hires a lot of like talented foreign workers. So there's a little bit more balance right now in the current administration. But how this is gonna play out, we don't know yet. But at least this time we see a lot of, like, especially Silicon Valley tech companies are sending a lot of lobbyists to the Trump team to see if they can bring some changes to the business immigration, right? So there can be something different, but we don't know yet. But there's something at least to balance off the Stephen Miller side a little bit this time, because during the first Trump administration, a lot of the employment-based categories were affected, including EB-1A, including H-1B, right? So those were all affected. We hope they won't be affected as much this time, but we will still have to wait and see. All right, next slide. Okay, yeah, that's pretty much it. So I'm gonna open this for some questions. Yes, thank you very much.
Thank you, Meng. It was very insightful information. Any audience member here, if you have any questions, short question basically, before if you have a very long question, you can reach out to her. There is information right there on the page. And yeah, unmute yourself and go ahead and ask some questions.
Hello.
Yes.
That was very informative. Thank you. I'm more interested to know about that student related because I'm almost in the end of my advanced degree now. So, like talking about the research articles, they are under process, not yet out. And as you mentioned, being in the student scenario, also you can apply for, green card petitions.
Right.
However, I was also curious about that OPT 1+2 extension. So I was not much clear on that point. So should I wait for my degree to be in my hand and then start it, or should I start it now in F1 status? I'm kind of like, not sure in that part.
I see. Are you concerned about like the impact on your eligibility to get OPT, or
No, I'm not concerned about getting impact on the OPT eligibility. I'm concerned about like would it be nice for me to start now because or not?
I see, I see. Okay, thank you very much for your question. I would say, first of all, it's very case specific. So we probably need to, see your CV, see your publication to evaluate the case first. But degree is usually not something that critical to the overall, the success of the case. We have seen a lot of students who were still in their PhD program, or some of them were even in their master program and started the process for NIW, and they got approvals as well. So you don't necessarily have to have the PhD degree, like say, obtained in order to get that. But we do usually need an advanced degree, as we said like before. This is a prerequisite for NIW. So for someone who doesn't have like an advanced degree yet, usually we would recommend like wait out a little until they get the advanced degree. But if they already have one and they also have all these good publications, citations, it sounds like they are already ready to start the process. So if you're interested, we would be more than happy to do a complimentary evaluation of your case for you. You can contact us by this email.
Well, thank you so much.
Sure. Okay, I saw a question in the chat. Do we need to have a valid passport for both main applicant and dependent for filing the I-140 and I-45? That's a great question. For I-485, yes, you would have to have a valid passport at time of filing for the I-45. I-140, I don't think so, because at that time, the USCIS doesn't care about your status. They only care about your professional achievements. So that wouldn't be an issue for I-140. Okay, next one. What would be your recommended route for someone on OPT right now and is employed with an H-1B cap exempt employer? Okay, there are two options you're contemplating. The first, be on a cap exempt H-1B and look for NIW. Continue being on OPT and look for NIW. I'll say if you haven't used up your OPT time yet, it seems like just continuing on OPT may give you more flexibility, right? Because it would be a lot easier if, for you to change job if you're on OPT than, getting an H-1B. The only benefit I can think uh, of getting like the cap exempt H-1B before you use up all your OPT time is if you have to travel, right? If you have already, like say, especially if you have already filed the NIW immigration petition, and then you have to get a visa overseas, then there is benefit of going on the like a cap exempt H-1B, because H-1B is the type of work visa that allows dual intent. That means you can have immigrant intent and you will still be approved for immigrant like the H-1B visa overseas. But if you are OPT, you are still an F1 student. So when you are applying for visa overseas, you still have the burden to prove that you have no immigrant intent. But if you have an immigration petition filed already, that would be a little bit more challenging, right? So that's the only benefit. But if you stay in the US, it sounds like, continuing on OPT doesn't have much downside. If there's anything I miss, feel free to type that out as well. But either way, you can still start the NIW process for now. Okay, next question. What would be a case for a person who have master degree in physics from Nepal and doing PhD in electrical engineering in the US? Does he qualify for NIW from his master degree or wait for a PhD? That's a great question. I should have covered that earlier. Overseas foreign masters still qualify for NIW advanced degree purpose. But usually we need to do an evaluation. So what we do is first get a US evaluation agency and ask them to issue a report, attesting to this foreign degree as the equivalent to a US master degree. If the degree can be evaluated by a US agency with that kind of report, then that has already met the prerequisite. You don't necessarily have to wait for the US PhD degree. But again, like that's just the prerequisite, right? We still need to look at your actual achievements, like papers, citations, conferences. If we have all those, then PhD is not an issue. We actually do see a lot of the PhD student apply for NIW based on their foreign master degrees, or while they are pursuing their PhD program, they already have a master degree like from the US that can be used as well for the NIW prerequisite purpose. Okay. All right, I think we are pretty much at the end of our today's presentation. Thank you so much for having me. It's a pleasure speaking to you all, and I wish everybody happy holidays and a great new year. I'm gonna give the floor back to our host today.
Okay, thank you, Marta. It was really pleasure you having you here in our community. I wish we had these kind of things when I was in that board.